I've always wondered about that, by the way. You mind if I interject here? How is it that they can keep it from the clients? I'm not sure that you can do that when. Hello to our Nevada Judges Land. I'm Adam Ganz, and I've been voted to moderate a panel of experts about experts today. So it's going to be quite the discussion here, but I wanted to go around and see if we can get everybody introduce themselves if we could. How about we'll start over here if we can.
All right, thanks, Adam. My name is Andy Wong. I am a criminal defense attorney here in Las Vegas. I have been practicing for about 10 years, mostly focused on federal casework.
Good afternoon. I am Judge Joanna Kishner. I am a judge here in the 8th Judicial District Court, Department 31. I've been a judge for about the last 14 years, and I'm a Las Vegas native.
I'm Kimball Jones. I'm a trial lawyer, civil litigation, personal injury, and other types of cases, insurance bad faith cases. And I've been practicing here in Las Vegas since 2013. And I love it. Love going to court, love going to trial, dealing with experts.
All right. And my name's Adam Ganz. I'm the current ADR and Discovery Commissioner for the 8th Judicial District Court. I work with the judges. I work on cases involving discovery disputes. I'm on the bench a couple days a week and also supervise with one other ADR Discovery Commissioner. We supervise the ADR program. My background is 25 years of civil litigation trial work. Probably tried about 75 civil jury trials over my career and handled thousands of cases. And now I've transitioned into being a neutral. So that's what I'm going to try to do today and see if I can stay neutral, although I'll jump in and give my comments about certain issues here today. But I was hoping to moderate the panel in a neutral capacity here today, since we have different aspects and different experience from everybody here. So the first question that came in about experts is, what are the differences between a lay witness and an expert witness? Who wants to go first and handle that?
Do you want to talk about it from
Sure.
a litigator standpoint?
Let's go down the line here.
Yeah. So a lay witness is somebody who has observed something that's occurred. They have history with a person. So you might have a lay witness that has observed a car crash. You might have a lay witness that is a friend or relative of an injury victim who can talk about what the person was like before the injury, after the injury, how it impacted their lives. Those would be lay witnesses. And an expert witness is somebody who, in some established field, has a degree of expertise that they can bring and explain that you have to have some sort of credentials or some sort of experience. And so typically, if you have a neurosurgery case or a spine surgery case, you'll have an expert who is a spine surgeon that talks about issues such as causation of the injury, the costs associated with the procedure, and future care issues, things like that.
I think the short answer is whatever the judge says is the difference between a lay witness and an expert witness. From a judge's standpoint, there is a clear distinction in trial.
There is.
The difference between a lay witness and an expert witness. What, from your perspective?
Well, in fact, we have a jury instruction, right, which talks about the difference, and there's actually certain rules that talk about the difference about a lay witness. As Kimball described, lay witnesses usually have either seen, felt, touched, heard. You basically your senses of the issue at hand, whereas an expert witness has specialized knowledge, and given their specialized knowledge, they're allowed to provide opinions and actually address hypotheticals, which normally you can't do, with a few exceptions, for lay witnesses.
And you both have been talking essentially about civil
Yes.
Witnesses, lay witnesses, and expert witnesses. Andy, what about from a criminal defense or criminal standpoint? Excuse me.
So the same rules apply. A expert witness is somebody whose specialized knowledge or training is beyond what an average juror would understand, and it would help the jury understand the case, the testimony, what's going on, and that's the distinction between a lay and an expert. And obviously the judge says yay or nay on our experts.
So from my perspective as a discovery commissioner, The difference between a lay and expert witness come into play during the discovery process about whether or not somebody can charge for their testimony, whether or not they have to be designated at a certain time period. So from a discovery commissioner's point of view, those are some of the issues that we deal with. Also, we really get into the distinction between whether or not they were an initial expert witness or a rebuttal expert witness, and whether or not they're going to be offering testimony that goes to somebody's case in chief, or whether or not it actually is just meant to rebut somebody else's testimony. So there's even subcategories of expert witnesses as we go through it. Lay witnesses, we tend to also have a distinction, at least from my perspective, the difference between kind of a hybrid, and those are like a treating physician expert, right? Somebody who would have expertise, but may not be necessarily a expert witness that is going to be looking beyond their treatment. So those are hybrids as well. Do you want to comment on that, Kimball, a little bit?
Yeah, and I'm explain that a little bit more. So you're talking about somebody who has some lay experience.
Sure, I'm talking about a treating physician.
The exceptions with a treating provider versus a pure expert under the rules.
Yeah. So it's in some ways when you have that crossover, you actually have some additional flexibility that is that you don't have with just an expert or just a lay witness. So the treating provider can provide the expert opinions that are appropriate, that they know because of the treatment they've actually received, and they don't have necessarily all of the restrictions that a purely retained expert would have. And it makes sense because oftentimes in their focus taking care of a patient, they're going to be looking at how to take care of the patient, and they're going to develop a number of opinions and things that they're not putting together an expert report on all of those things all the time. And so they end up serving the role of somebody who is observed, but also can provide expert opinions in certain areas.
And I think from a discovery perspective, a specially retained expert, somebody who's provided documents and stuff outside the scope of what they would normally do as a doctor who would see somebody, that would be the distinction between a treating physician expert and a specially retained expert. They may get the traffic report, or they may get pictures, or they may get other things that normally you wouldn't do during your treatment. From the discovery perspective, oftentimes we have to evaluate whether or not that person who has expertise needs to write a report or not write a report. And there is a provision in the rules under expert witnesses that we can forego, or we can say that somebody does not have to write a report and still be able to testify about certain things if it's in their medical records and there's certain opinions in there. Now, as far as admissibility at trial goes, their opinions can certainly, I know that's a big contentious issue, at least it used to be when I was trying cases, was what is the scope of what a treating physician expert can testify to as opposed to a specially retained expert, regardless of their expertise. But I'm not talking about whether or not they're going to be admitted because of certain expertise under the Hallmark case that we all are familiar with. But I'm talking just by a disclosure issue about what was produced and what they actually said. Can you comment on that, Judge?
Well, you mentioned Hallmark. Hallmark is a case which actually is going to tie in, I think, to another question kind of coming up a little bit of how people can be designated as an expert. But Hallmark walks through certain criteria that someone needs to have to be an expert. And although we've focused a little bit on medical experts, really experts aren't just doctors. I mean, experts can have somebody specialized expertise in mechanics, a whole bunch of other topics. It's just they need to have a specialized expertise. But when you're talking about the distinction specifically with a treater versus a pure expert, you have to look at, okay, for example, is a person who normally just does a general physician, and if they're trying to talk about heart surgery, right? Well, that wouldn't fall within their treating role, because in their normal everyday lives as doctors, they treat people on a general practitioner type situation, or maybe an internist, and they're not going to other things. But they may have reviewed records with regards to certain, assuming they have the background skills and expertise, which is a little bit of a different topic. They may have reviewed records about a person's prior heart condition or something like that, which they're saying is tied or not tied to an injury that may have been caused or not caused on a pending case, whether it be personal injury case, etc.
Excellent. And what about from a criminal law perspective? Is there a distinction between what we were talking about, like a treating physician expert, or maybe somebody who is, been involved, let's say, as a police officer, for instance, versus somebody who's hired to talk about security issues, for instance?
Um, so in the criminal context, what happens is the state is pretty savvy about it. They will separate it out. So if you have an officer who was the lead investigator, they will have either another officer or case agent be the specialized expert. So in my experience, there's very little overlap. The government wants to keep it very clean that this person was a recipient witness, they did the investigation, and this person it may have the same expertise, maybe come from the same agency, but they are the separate designated expert witness.
Okay.
Which makes practical sense because in the criminal context, oftentimes you're dealing with life and liberty type issues, right? In the civil context, oftentimes you're dealing with someone who's injured or you're dealing with monetary issues. And the rules with experts really have changed. I didn't really mention I've been an attorney since 1989, and so the rules have
And
changed.
you do both criminal and civil, right? Or you have over the past?
I have, well, my current docket is complex business litigation, complex construction defect, and general civil litigation. I do overflow criminal, done criminal in the past as well. But our rules have also changed here in Nevada. I mean, in 2019, there was some significant changes to kind of blend in the concept of what was custom and practice versus some things that may have been specifically in the rules. And that's kind of where that hybrid treating
Right.
physician was more clarified. And so the law is evolving, and this topic will evolve as well.
Absolutely. And so the next question is one of the things that actually has evolved over the years. The question was, how does the court determine whether or not to certify a witness as an expert? And of course, that no longer exists, right? In that sense, the court is not actually tasked anymore with actually certifying that somebody is an expert. As a matter of fact, you don't have to do that anymore. It used to be that you would say, and Your Honor, this time we'd like to move to have this expert certified as an expert in this area of expertise, and we're no longer able to do that, right? I mean,
You're right. There's actually a couple of cases. Two of them are Mulder versus State and Villegas versus State, which are two criminal cases, but they have general civil implications as well, where basically the concern was that if someone had this, quote, title expert in front of a jury, that somehow they would have an elevated view of what is their testimony versus other individuals. And so now, while we still have expert witnesses, the more proper way is basically for someone to, quote, ask the opinions of the witness rather than qualify them as an expert. Although from the behind the scenes, in order to be able to testify, to give those opinions, they have to meet standards under the applicable case laws. And we mentioned the Hallmark case, there's Moriscato, there's Williams, there's a couple other cases that talk about what are the qualifications in order to offer those opinions.
and I think that's what the question really meant
Yeah.
was, what does it take in order for an expert to qualify to be able to testify as an expert at trial? Kimball, you want to take that one?
Yeah, they just have to have the specialized knowledge in the field that you're talking about. So, Judge Kishner just mentioned that you could have a mechanic, and so maybe you need a mechanical opinion, and you could have somebody testify on that. You could have a police officer talking about a crossover expert who also has been trained in accident reconstruction, right? So if you have an accident reconstruction case, it's that. But someone who might be an accident reconstructionist may not have. They might be an engineer and they know how accidents occur and they can identify a bunch of important factors there, but they might not have the expertise of something like biomechanics, for example, which is a little bit of a touchy area. I'd say still. The Hallmark case, which is kind of, it's the Hallmark case, but it's also called Hallmark.
Yes.
Yeah.
Is it Hallmark Eldridge, I think it is? Is that
Hallmark versus Eldridge,
Yeah.
from 2008, I believe it is.
Yeah.
And that's the case really that it deals with a biomechanics, right? Human biomechanics expert who really wasn't. At least he didn't show himself to be during the case and ended up being reversed and remanded. But in that case, the expert didn't have, although he was clearly an expert in a number of fields, he didn't have the expertise to say whether or not a person was likely to be injured or not based on the facts of the collision itself, right? And so on some of these areas of expertise can be really, really nuanced. Some, it's very straightforward. You're a spine surgeon or you're not. You're a pain management physician or you're not. You're an engineer or you're not. But you can get to some nuanced areas where there can be even a question of, can you actually be an expert in certain areas? And if you can be, what does it take to be?
And technically, the Hallmark decision, again, not dealing with it in discovery disputes generally, the Hallmark decision set out certain factors that the court needs to take into consideration to be that gatekeeper to make sure that they qualify as somebody who can testify in those expertise. Is that something they do? I know in federal court, it's a different standard. It's a Dahlberg standard.
Yep.
And the progeny of cases that
Yep.
have come out from there. Why don't you give us some overview of that, if you would?
So the feds have codified it in Federal Rule of Evidence 702, really easy to remember. And the judge serves as a gatekeeping function. There needs to be a notice of the expert, an opportunity for the opposing side to challenge the expert, and then if the court deems it appropriate to have a full Daubert hearing where you go through the 4 factors listed in Rule 702, and the judge will make an initial gatekeeping determination of, yes, this person meets the standard under 702 and they can testify as an expert, or no, they have not. They will not be allowed to testify as an expert.
All right. And Judge Kishner, I know a lot of that is probably dealt with in motion practice and argument, but what about actually at either an evidentiary hearing or what they call when you're voir diring a witness? Does that happen a lot in your courtroom, where they actually want the person on the stand and people question him whether or not their expertise or as an expert, or even you do maybe?
It has happened. A lot is always an interesting term because I don't have a comparison. Each of us, there's 32 civil criminal judges in Clark County. And remember, we're talking about the district court level, which is the trial court level. Of course, there's additional judges, justice court. We have small claim referees. Obviously, there's federal court, et cetera.
Family court.
Which
is
as well.
Completely separate.
Very different. And so what we look to is if someone's being challenged for their expertise, then sometimes we will do a voir dire. Either we'll do a voir dire a month or so before trial to try and get that worked out. And it's really a lot of that I rely on the attorneys on when it makes the best sense to do it. Because some people like to do it right before the time of trial. Other people like to do it a month or so in advance because they want to prep and they want to know whether or not this individuals may or may not be able to testify. So we do that, and the length really depends on how much information. We usually have both the attorneys, if it's a 2-party case, are able to ask the proposed expert questions, and then if the court, i.e. me, has additional questions, I will, and then make a determination about whether or not that person can testify in whole or in part as a expert witness, or if their testimony has to be limited in some regard, or possibly not at all. And once again, it's very case specific. There's no generality there.
And it's interesting because when I was practicing and Hallmark just came out, we would actually be in the middle of trial sometimes, and people would ask to voir dire witnesses and to make sure that they satisfy to do that. Kimball, have you ever had to do that in cases?
Yeah, a few times where there's really, I've done it in the middle of trial, right? So that, in fact, I think in my experience, when I've actually done doing a voir dire of an expert from the other side, it's typically been in trial, and right when the person's going to be testifying, the judge will call them, take the jury out. The jury won't be in the room. And then I get to grill the expert on the stand and try to prove my point to the judge that this expert is not qualified for whatever reason, or doesn't have the right foundation for the opinions they're claiming. And hopefully, I get a decision from the judge that says, yeah, the expert either can't testify to that or, is limited in some way. And sometimes the judge says, no, you're wrong, and I'm going to let the expert say what he wants to say.
Do they do anything like that in federal court?
It's always handled well before trial. There's a whole separate hearing. I had one, my last hour hearing was set for 2 hours. It went the full day, where the judge actually issued a written opinion about whether this or my expert could come in or not. So it's.
Did you win?
Yes, I got it. Of course I did. So yes, it's very formal and very orderly, and everyone knows well in advance whether that expert's coming in or not.
All right. So I think there are a couple different answers to this question. How do they qualify to be an expert? Number one, they need to be listed timely. There's also certain requirements from, again, a discovery perspective that I get involved in order to determine whether or not they've been listed appropriately, not only timely, but also that their opinions satisfy all the requirements of our local rules as well as our case law and everything else. So that's kind of the procedural aspect of getting it done. And then there's also the actual substantive aspect that's dealt with typically at the district court level, whether or not they actually qualify to testify and what exactly they can testify. Just saying someone's qualified as an expert doesn't really give you much. But if you say they're qualified to testify to certain areas or certain expertise, and they can talk about those areas and not go beyond that. In other words, a neurosurgeon generally doesn't talk about whether or not someone's got a problem with their nose or their eyes or something like that, unless it has to do with an overlapping neurologic issue. So the idea is that just because you're a medical doctor doesn't mean that you're an expert in all areas. Although a lot of attorneys think that a lot of people think that attorneys are experts in all different legal areas, even though we're not. And some of us who don't do as much criminal obviously would defer to the criminal law lawyers, and vice versa, I would assume. So, well, moving on to the next one. One of the next questions was, are expert witnesses the only type that are allowed to be paid for their testimony? First of all, from a discovery standpoint, most experts do charge a fee for their time. There's a case that came out many moons ago in the discovery realm, called the Houck decision, where the discovery commissioner required that a medical expert provide information on how much their annual income is and how much time was being taken out of their practice, and they determine what their hourly rate can be, because doctors don't tend to charge by the hour a lot of times. So that's kind of gone away with over time, although if we ever had to actually do that, I imagine we could have a Houck hearing or question that. But expert fees are often questioned in discovery. The motions are brought to say that they're charging too much per hour or too much. They're requiring 5 hours of prep for a deposition, for instance, which our rules don't allow for, or they're charging $3,000 or $4,000 an hour, which may or may not be, reasonable within our community. That seems fairly unreasonable. I don't know if I've seen an expert that charges that much, but certainly the expert fees are definitely going up with inflation. So experts do charge. The question is, does anybody else get to charge for that? I think we talked about a little bit like the hybrids. So treating physicians may not be a specially retained expert, but certainly they're entitled to their fees, right?
Right. And, I actually don't know the answer to that question. I've never paid anyone that was not an expert. Obviously, there would be a physician, a treating physician who I would pay them for their time to.
What about a
meet
lawyer?
with them.
You ever have a case, in a bad faith case, where you have to, have a lawyer testify as to whether or not it's bad faith, or even whether or not that lawyer was part of the case?
Yeah.
Do they get to charge for their hourly rate to have to testify as a recipient witness in that situation?
Yeah, so I know, of course, that they could in that situation. Just through personal experience, through the cases I've done, I don't think I've ever actually paid anyone unless they were designated as an expert for the purpose at trial. But so I don't know if there's a rule precluding, like a lay witness. I don't. It feels like that wouldn't be appropriate. But when you have somebody who's actually an expert testifying to some degree in their expert capacity, that seems pretty normal to me, whether or not they are only in the case for that reason or because they're a combination expert plus recipient.
Well, from a
It
judge,
has.
you want to have that?
Well, although it's minimal, any witness subpoenaed gets a subpoena fee, and that technically is right, getting paid. So they're getting the minimal subpoena fee plus mileage. But also what you have, and particularly, I said I do complex business litigation, a lot of executives, right, are coming from businesses to take their time. So they do charge sometimes for either deposition testimony time or for trial time. And they're not an expert. They can be a recipient witness. The question is charging their client versus whether or not that's a recoverable cost that they can then put on the other side. And that's a whole nother topic area about
Sure.
attorney's fees and costs recoverable after a case is over. But so yes, it does happen sometimes, but usually the issue only comes up if somebody's trying to attribute that cost to the other side.
Yeah, and I actually get some motions like that occasionally where, let's say, a neurosurgeon witnesses a car crash.
Mhm.
And they go over there and they ask the person if they're okay, but they don't really provide any treatment. They're not actually testifying as a neurosurgeon. Are they entitled to their fee for having to take the time off from work from doing that? And there has been arguments on both sides about that, whether or not the person is entitled to do that. And certainly, I think there is a big distinction whether or not they're offering expertise and opinions with regards to their expertise, and whether or not they should be able to charge as an expert. Or as a neurosurgeon, for instance, charges, or if it's just somebody as a recipient witness. So the answer to that question, I think, is it depends.
Yes.
We love to give that answer, especially when we're in the middle, because every case is different. And we don't like to make any, hard and fast rules about things. But the reality is that there could be circumstances where, let's say, somebody's having to travel, or somebody's having to do things that we may agree that it would be appropriate to compensate them for that because they're a very important witness to the case. So anything to add to that, Andy?
No, like Kimball, in my personal experience, I've never had an issue of a lay or recipient witness being paid. The closest I've ever come to is the witness is in some criminal justice trouble themselves, and the state has an obligation to disclose, like, yes, we've cut a deal with them in exchange for their testimony. It's not cash in hand, but it's definitely a benefit.
Well, that's a great segue to the next question that somebody's asked out there, which is what mechanisms are in place to deal with the potential issues of experts testifying in favor of a person who pays them the most? And we all have heard these stories about experts charging, some experts, charge $1 million a year for their testimony, and just doing testimony as opposed to their actual, medical practices, for instance, or those other things. So are there any formal mechanisms for dealing with that as an attorney?
Nothing formal. I mean, all you can, as far as I know, there's the way to deal with it is you show the jury that this guy is a hired gun without saying hired gun. I mean, you let the jury see the truth about what's going on here. And so, a trial I had about a year and a half ago, 2 years ago, the expert, I got him to confess on the stand that he takes about 200 cases a year, charging an average of more than $10,000 a case. And then you kind of weave that into the rest of the reality that his opinions are not credible for a variety of reasons. And the jury they're reasonable people. They look at this and they say, well, yeah, this guy is a guy that this is how, he's making a killing by offering the opinions in favor of the people paying him, right? And that's, that unfortunately, and I think it is the case that a good number of the experts that we deal with in trial these days are those types, right? Whether you're able to get that kind of a confession, right, where you're able to elicit what they're really making and everything, there's a reason why the same 3 neurologists show up, for the defense in civil cases, in brain injury cases within the state of Nevada every time. Well, their opinions from one report to the next, as you said, Adam, the every case is different. Well, the reports are not different, right? Even though the injuries can be quite different. So now, with that said,
but every doctor out there, who's just treating people want to come to court all the time, don't they? Isn't that the argument on the other side, Kimball? Honestly, it's hard to get doctors just to see you sometimes when people are in or injured because they don't want to be involved in litigation, right? So what are you going to do? You got to go out and pay somebody, right? Isn't that the argument on the other side?
Yeah, and it is actually the case that there are doctors who will kind of shut down treatment of a patient because they know there's potentially litigation involved. That does happen. That's too bad, but I understand. Some doctors, they just don't feel equipped dealing with that when somebody gets injured. But yeah, it is
usually
because
they've been burned by lawyers, either on the plaintiff side or defense side, and they just don't want to be involved in it. This question, actually, if we frame it in the way and the technicality of bias, and I don't mean technicality, but I mean the discussion with regard to bias, right? Isn't it really about bias, Judge?
Well, what Kimball was referencing is many judges, when you're trying to, because same thing with an expert, right? In fact, like I said, jury instructions, like I think it's pattern instruction 3 and 3A, I think, are two of the instructions that deal sometimes with experts, is the jury, if it's a jury case, gets to determine the credibility of the witness. And one of the things you can evaluate a bias, any witness, the same thing with a lay witness, you would evaluate whether or not, in fact, there's a different jury instruction that talks about that, whether they're related to the underlying people. Do they have a vested interest? If it's a business dispute, right? Are they one of the owners? Are they a beneficiary on one side or another? When it comes to certain experts, you can look at bias by seeing the fact is, are they going to personally benefit by their testimony? Certain questions can be asked in that area. As to the specific question about whether or not there's a specific mechanism, people are able to freely negotiate if they want to be an expert. There's some individuals who never want to be an expert and won't take any rate of pay. Other people charge a premium, and that really is part of our free market system. So there's not something that the court would control for how much someone can be paid. It once again comes kind of on the back end on about whether or not you can allocate that cost to the other side, depending on the result, if it ultimately goes to trial.
And there are some extreme situations where bias does play into whether or not an expert can testify too, right? Isn't there some situations where it just becomes, I could imagine, and we had some in the past, but I don't know if you've ever had that experience or not, where an expert has been so completely biased towards one side or the other that you don't believe that they're appropriate for the jury because it make it confusing. I would imagine it could get to that level.
I am personally not experienced that. I'm aware of case law where the issues have been brought up. I'm aware of hearings where it have evaluated that concept, but personally, I've never had someone file a motion that has said that somebody has demonstrated once they've testified such a bias as that they can't testify. We've had other issues where some experts have had other things happen in their personal lives, and whether or not that would preclude them from testifying, right? Or find out you have a relationship to the case that might not have been disclosed, might preclude you from testifying or limiting your testifying or getting that information out there, right? So that it's publicly available, once again, for the bias thing to evaluate bias and credibility. But the specific example, I personally have not had that I can think
Okay.
of in the last 14 years.
And Andy, what about, I mean, it doesn't have to be just money, right? I mean,
Yeah. Mhm.
you know, whether or not someone's been given a deal or whether or not they've, you know, worked with a certain agency, that can go towards their bias, and whether or not, is there any mechanisms either in federal court or state court that you utilize in the criminal law setting that would be able to point those out to the jury?
So there's no specific mechanism. Like Kimball said, it's all done on cross-examination. And if I find out if they were a cooperator, they have an agreement, and especially if I have that agreement in front of me, I'm going to set up shop and I'm going to live there, and I will convey to that jury that this person is getting a benefit. They have every possible motive to testify against my client because, you know, they're getting something, you know, it could be they're either staying out of jail or they're getting out of jail based off of what they say right here, right now.
Does anybody else have anything they want to add to that issue regarding getting paid as experts? Anything else?
No, I mean, I think it's an important thing. You can't get the experts to, I mean, their time is obviously valuable. They're specialized in an area that makes their time valuable, so you need that. But there's a corruption that comes with the system, and you have to rely on the jury's common sense to kind of figure out when this is you have variations. Sometimes you have reasonable experts disagree. Sometimes you have experts that maybe they shouldn't be disagreeing, but they're maybe too caught up in the competition of the thing, right? And then sometimes you just have guys who, for one side or the other, they're gonna say what they're gonna say, and you can just guess the next 10 reports that they issue, they're gonna be the same as the last 10, right?
Wouldn't you think that, I don't know if you got this sense or not, but it seems to me that jurors aren't as offended by those big numbers anymore. They're not as offended as they used to be, it seems. Maybe I'm wrong about that, but what's your take on that?
To me, it's not so much the numbers themselves. It's the honesty. It's the sincerity, the frankness of it. So, just as an example, right? So, I might have an expert who takes the stand, and the expert may have been paid $50,000 for an enormous amount of work that's been done in the case, and there was no way around it because he's such a highly specialized person, and he had to go through 50,000 pages of material. and it required that amount of time. This guy spent weeks on this case, right? And so you can have that situation, and the jury is not going to be offended at all by it. But on the flip side, even a smaller amount of money, if the person is deceptive and they're untruthful about it, or it's part of a larger scheme, like I mentioned, 200 cases a year, basically all of the same opinions, right, every time, that sort of thing offends anybody. But one of the things in cross-examination that I've found can be very effective is you get the guys that are really in it for the money, right? They really are nervous.
You
about
said
the
guys
money.
a few times. There's also women that testify as experts, right?
Absolutely, and I certainly I haven't had I will say that I've certainly cross-examined female experts, but my experiences so far with those that have been the most egregious have happened to have been male experts. That just happens to have been true in my case. But yeah, you ask the expert, you say, how much you've been paid in this case, and how much is the defense paying you? And they start out and they lie to you. Basically, they say, oh, I charge $6,000 for half a day. Sir, can you please just tell the jury the truth about how much you've been paid? Did you charge six? Is that all you've been paid in this case? Well, no. In fact, the council already paid you $12,000, right, for today. Right? Yeah, they did. And then you slowly over 15 minutes. I mean, I had this happen in a trial once where I probably spent 10 minutes just having to pull out every additional invoice from this particular expert. So the fact that he charged $50,000, I don't think that was the thing. It was that there was a dishonesty about it, right?
And Judge, you, I'm sure, talked to jurors after, maybe not now in the business court setting, but when you were doing regular civil docket, I'm sure you talked to jurors after. Has that ever been an issue of them where they talked about some of the experts?
Let me kind of partially answer part of your last question a little bit as well, because one thing you have to look at experts is not every expert is an expert in a personal injury case. Like, for example, one of my dockets is complex construction defect. When you look at complex construction defect, because of the nature of the statutory provisions under Chapter 40, in order to A, bring a claim, or B, defend a claim, you have to go through every aspect of the house for which you're making a claim, right? Windows, doors, stucco, if you're doing ground, etc. So by definition, those type of experts have to spend a lot of time because they have, whether they're doing, say there's 50 windows in a house, are they doing all 50 windows, et cetera, like that. So you can't just say that the numbers itself makes it one way or another. You have to really look at the nature of the work that is done, and I think jurors get that, okay, when they're looking at different cases, which is a different issue than you mentioned. One's the credibility of the language, the other is the actual work actually done. To answer your question about speaking with jurors, as a judge, I don't ask jurors their opinions on the underlying case. When I go in and I speak with a jury, and I do every time if they're willing to speak with me, which so far everyone has, pretty much, most people have, is I just ask them what we as the court can do better, and any thoughts or suggestions they may have. I confirm that they're being treated politely, that we're being considerate of their time, etc. Because remember, I as a judge may be getting post-trial motions, so I am very, very careful not to ever ask anything that could elicit anybody's viewpoint as to certain things that could be subject to a post-trial motion. So I really like to thank them for their service, because we have great jurors. I mean, our community, comes together and does their service, and they ask intelligent questions, they spend their time, they stay late on holiday weekends, etc. And so I want to make sure that they understand that we appreciate their time and make sure that they have been treated appropriately for individuals who are giving their time to serve on a jury.
And obviously jurors are very, very important. We can't function. I mean, the court can't function without jurors and people volunteering their time to do that. I know they get paid a little bit, but it's really the one service that we ask in the United States that you do is you sit on a jury, and it's that important. And I always tell people who call me and say, "How do I get out of jury duty?" I say, "You're calling the wrong person. Now you're going to hear my speech about why you should be on the jury." So in any which case, that's kind of a side note. Let me get back to some of the questions if I can. I think the next one's going to be kind of quick, because I don't know if any of us have the answer to this. But you, Judge, and I had talked about this, and I'm not sure I know the exact answer to it, but the question was, why does the exclusionary rule not apply to experts?
I have a practical response, although it may not be the correct response. And what that is remember with an expert, you're supposed to already have an expert report, so you already know what they're going to say, right? And so then for them to sit in the courtroom is usually not going to have the same concept that they might change their testimony hearing other individuals. That would be a practical reason,
So-
but I could not find, and I did look to see if there was any white paper or any analysis ever done on that. I did not see any, but somebody else might have a different answer.
Yeah, and just to make sure we are inclusive of everybody out in the world there that may not know what the exclusionary rule
sure, go
is,
ahead.
there is a specific rule that says one of the parties can ask that the witnesses who are going to be testifying in a trial doesn't hear any evidence that's going to be presented. That does not include opening statements or closing arguments, and does not include some of the sidebars and stuff like that that might be done to the public. Those are public hearings, so they can still be heard in those situations. But the exclusionary rule would say, for instance, if I'm testifying in a car crash case and I was a witness in it, that I'm not in the courtroom until after my testimony, or I'm released for my testimony, and so I don't get my opinions or my memory of the events clouded with what other people are saying, and certainly it's a rule that in most cases I think most people apply, but the question is why about experts? And just to pile on, if I could, I think experts also are listed, as I mentioned earlier, as rebuttal witnesses sometimes.
Mm-hmm.
So if they have to rebut testimony that's actually given in court, it seems to me that it would be appropriate for an expert to sit there. Anything to add to that, Andy, at all?
I can't remember if it's actually in the rule or if it came from a case that interpreted the rule, but in federal practice, it's very clear. The expert can sit through other witnesses' testimony. They're allowed to hear lay, and then obviously if there is an expert on the other side, the other expert's testimony. So, and for all for my entire practice, it's been black and white. Yeah, they're allowed to do it.
Do you have any thoughts on why that is, other than what we talked about, maybe?
Honestly, my gut feeling was because that at least in my practice area, they're all law enforcement, or they're all sort of technicians and scientists. So the risk of their testimony being influenced or led astray is minimal.
Anything to add, Kimball?
Yeah, I also don't know the reasoning behind it. I suspect the nature that some experts are rebuttal, but as I've thought through it, I mean, just in my practical experience, I have not found experts to be more reliable truth tellers than normal people, and so I don't frankly see a good reason for the rule to be that way, for it to be allowed that way. If you are going to have an exclusionary rule, which I think that concept could be questioned itself a little bit, but if you are going to have it, I really don't see a good reason for it to not apply to experts outside of the very strict confines of rebuttal capacity or something like that.
Yeah, it's an interesting discussion, and I don't know that we probably have almost 100 years of experience between us, and we probably haven't thought about it because we've always known that this is what it kind of is, and there are certain situations where you do want your expert in there to be able to hear the testimony, and it does happen not all the time, but sometimes, even when there's an exclusionary rule, right?
Well, yeah, and remember the exclusionary rule doesn't apply to clients, right?
Right.
And the corporate representative. So if you're the plaintiff, you can sit through the entire case. If you're the defendant, you can sit through the entire case, counterclaimants, or corporate representative. It involves corporations. So it's not a per se exclusionary rule with a carve out for experts. It really is, the rule exists to ensure that people are able to give their perceptions. And I think also from a juror's standpoint, they're seeing people giving their testimony based kind of fresh, coming in the door and being fresh. And once again, remember the experts, they do have to have reports. They're limited to their areas of expertise as written down in the reports. They can't bring in new opinions. And so you don't have some of those, I think, same concerns. But like I said, I couldn't find anything that kind of said, here's the genesis or the reason why it's done. It makes practical sense to me.
All right. Next question was, what happens if there are multiple experts and they come in with contradictory conclusions or have inconsistent findings, methodologies? That never happens, right?
Only every case.
So how do you deal with that as a practitioner? We'll get it from your guys' perspectives, because I think as a judge, it's a different standard, and we kind of let everybody put their case on, I would imagine. And there is going to be some inconsistencies. That's why we're there, probably because of the dispute. So from a practitioner standpoint, how do you deal with that?
I represent people always, right? I represent individuals who are dealing with something, and at the end of the day, the first thing I do, frankly, when I see this, is I evaluate: am I right? Is my client right? Is this legitimate and real? And if it is, then you look at the other expert and you say, how could he have gotten to this position, or how could she have gotten to this position that is contradictory? Usually it's staring you right in the face. It's a guy that's been hired 200 times in the last year, right? Or it might be something else. It might be something that in fact there's legitimate real room for disagreement, or they haven't been given certain documents or something. There's a variety of things that it can be. But whatever it is, if you actually have the case that is genuinely the truth, right, and the position you're taking is genuinely the truth to the best of the information available, then you just find the points where the other expert has not considered something fairly, right? And then you walk through it at trial with the jury, and you just make sure that you expose those things so the jury can see the difference between why your expert and what he's saying or she is saying is reliable, and why the other expert, what they are saying, is not. One of them is not reliable. When you have clear contradictions.
Well, I'm going to take the other side on that for a second, because people can differ, even with not being unreasonable necessarily, with their opinion on something, right? I mean, isn't that the nature of, especially some of the things that you're dealing with that are kind of squishy with regards to causation of injuries and those types of things? I mean, I don't know that I have the opinion, and I'm sure you don't have this opinion, that every expert who's hired by a certain side is only going to be given those opinions about that. But I do think that sometimes there's that gray area, right? I mean, it's you can't. I hope that you don't think that that there's always going to be someone dishonest if there's somebody who's got a different opinion.
Oh, I wouldn't
I don't
go
think
as-
that's what you're saying.
No, I wouldn't go as far as to say dishonest. I mean, I think people. No, in fact, I'd say the vast majority of the time there's not any dishonesty. Both sides are expressing a position that they, at least to some degree, believe, right? And so there are various shades of that, I think, a little bit. But I do think that almost always there are major flaws. When you have direct contradictions between experts, I can't think of a case I've been involved in where there were not major flaws by one side's expert. So, for example, literally did not review the MRI, right? Literally did not have the video showing the speed of the vehicles, right? I mean, we're talking about major error. When you have direct contradictions in an area that is scientific enough that people are very specialized in it, and you have a lot of evidence, typically one of them is missing something. There's something that's going on. Now, you can have other areas where, well, just a simple case. Somebody has a back injury and they have a history of back problems, right? But they did have a back injury in this case. You can get some very nuanced opinions about how much of the ongoing issues really comes from some pre-existing situation, and how much of this was exacerbated by this event that occurred, right? And so you can have those where you have some different opinions, and the science is well known, well understood, and they view it a little bit differently. Because frankly, scientific studies on some of that can tend to be a little bit nuanced. But when you have really stark contradictions, usually somebody's way off in left field, in my experience.
Andy, what about you? How do you handle experts with contradictory conclusions and opinions on different sides?
So most of my experts are what are called like the experience-based experts. They're not necessarily like scientists or PhDs. They are able to testify as experts through years and years of training and experience. So
Can you give an example?
an FBI agent.
Okay.
Let's say I have a case about a drug operation. If the agent was focusing into those types of investigations, they are routinely qualified as experts to testify, to give the jury a framework of like, these are how these things work, because obviously by their very nature, they're not out in the open and regularly known, despite what you see on TV. So I would agree with Kimball that there's nuances on the edges of those types of experts. I've worked with retired FBI agents who say, actually, he or she is right about 90% of this, but, because it's not this type of organization or it doesn't involve these players, it's different and they can't come to this conclusion.
Interesting. So very, very different in the different areas of practice, it sounds like. The next question has to do with an access to justice question, which is what happens if a litigant is in form of pauperous, meaning that they can't afford to litigate, but they're still trying to, and they can file certain papers in order to get classified that way, so they get certain things that are not going to be charged them that they normally would be charged if they were not. And what happens if they can't afford an expert? Judge, I think this is probably best for you to handle.
Okay.
Your voice is a little...
My voice, I should apologize in advance. Unfortunately, I've been very, very busy, and so kind of lost my voice a bit because of all the work I've been doing lately. But hopefully everyone who's on the Access to Justice Commission and on a lot of the legal aid providers boards. Okay. Well, I actually checked with one of our legal aid providers to try and find out the answer to this one, because the court system in form of pauperous generally governs to be able to do the pleadings without cost, right? And there's a different type of where you can get certain exceptions for certain things that the court can pay for. The courts don't have budgets for experts, right? And once again, I'm focused on the district court level because if you're in small claims, there's actually a rule that you can't even have experts in small claims. You have it in different parts of justice court, but you can't have it in small claims. So realistically, it depends, because if you're in form of pauperous and you're being represented by one of the legal aid providers, they're not required to, but they may try and see if they can reach out to someone who might be able to do their time in advance and not take a fee. And then if there are recoverable costs, then recover it then. They don't have a budget specifically for experts, right? Because they get volunteer attorneys and they have on-staff attorneys to handle certain things, but they don't have like a crew of people that say, hey, we'll be volunteer experts, okay? The federal side's got a little bit different potentially, and I don't want to speak too much on the federal side because I'm not as familiar with exactly how they handle their budgets. And so realistically, it's an issue to ensure that everybody has equal access, but oftentimes when you're talking about a personal injury case, which is some of the cases that most often have experts, oftentimes those individuals have attorneys, right? Because they may be taking it on a fee structure that allows them to defer fees and costs until the end.
And those fees are usually advanced by the law firm in those cases, in some instances, right?
Yeah, for sure. I mean, in basically all instances when I've been involved, I mean, we end up covering the costs, and then at the end, the costs get repaid. But yeah, creates some risk. You want to make sure that that the case goes well for your client.
Yeah, and I also do family court discovery, and sometimes we'll have a motion for sanctions filed by somebody who works for one of the legal aid societies, and they're not getting paid, but they ask for sanctions to be reimbursed for the time to have to go through the discovery process. And there is case law out there that says that they're entitled to a reasonable rate, even though they weren't charging that to the client, but they are entitled to pay back to the agency who did the work if they had to do something that was sanctionable. So I always found that interesting, and certainly those little nuances in the law allow for that with regards to that. Obviously, the court is always looking for ways to increase that access to justice, and certainly having expert witnesses for somebody who can't afford them and does have a legal aid that's doing it on a pro bono basis, or even an attorney that's doing it pro bono, there may be some mechanisms that they can do in order to try to get that done or get reimbursed afterwards, like we're talking about. So
if you walked, if you walked it through, if the court were trying to retain an expert for somebody, that would be actually putting themselves into the middle of a litigation, which we as judges can't. I mean, it's the scales of justice. We stay fair and neutral. So
yeah. Exactly.
I'll say it's really tough. Like I see pro se litigants like come in and try to represent themselves, and it's so difficult.
You don't see half as many as we do.
No,
we see them a lot. Right. I had a hearing yesterday. Anyway, my point is that, am I wrong, Judge? I mean, maybe not in the business court setting, but in family court, I can tell you that I would think the majority
Right.
of the people who are in family court are pro se or representing themselves. And oftentimes, they now have a new program. I don't know if you guys are aware of this. I'm sure you are. But they have a new program now where it's an informal type trial, where if they're both improper person, which happens a lot in family court, that they can actually go through a very expedited trial procedure, and the judge will ask a lot of the questions in order to be able to get to the issues that they need to and get the people divorced or custody or whatever else needs to be done. But that's kind of a side note.
Yeah.
Sorry, I didn't mean to cut you off, but yes, you
Yeah.
do deal with them from your perspective, I'm sure, as well.
Well, and I don't deal with them. I just observe them, and I think to myself, if I were a person that is not a lawyer, trying to traverse this complex process of civil litigation, wow, I mean it's tough, right? So, you take a few pro bono cases when you can, right? But
And feel
it
free to
is-
take more.
She's on
Sorry.
the, yeah.
Mhm.
yeah.
I always encourage pro bono. Go ahead. Sorry,
Yeah,
didn't
I mean
interrupt.
it is really a challenge. I mean it just really is. And so when I see it, you have a personal injury case. If it has merit, usually someone will help you and will represent you.
And that's the
related to that.
stigma, right? If they don't,
Right.
if they can't get an attorney to represent them, it's because the case doesn't have any value. But that may not be the case in all situations, right?
It may not, but also there are specific areas. I think there are just flat out areas of law where there are people that are being harmed and that nobody's helping them, right? So like you deal with issues like lemon law, right? Somebody gets a bad car. Most attorneys cannot work it in their budget where they're going to go litigate this thing for the next year and a half over a $20,000 loss on a vehicle or something like that. And so there's not an economic dynamic that can make sense. Anyway, there's some areas that are a little bit problematic. And so the access to justice, I mean, it is obviously a real problem, but it's a real problem.
Sure. I will tell you that currently we have a bill that we've been talking about that the ADR commissioners, myself and Commissioner Truman, we're trying to get passed to increase the value of our arbitration program. And the arbitration program is a more informal setting. So currently it's still up in the legislature. Hopefully by the time this thing is out to the public, we'll have the opportunity to be able to say that it's passed. But hopefully that does give access to justice to more people, because it does give a more informal process by which people can have their cases litigated, and cases that people maybe not take because of that. So, and certainly in the criminal setting, we're kind of getting
It's very
sidetracked here with
different.
the access to justice. But is there any mechanism to pay for experts when people cannot afford representation and/or the experts?
So I will say, because people's life and liberty is at stake, the process is very different, but also very straightforward. If they have an appointed attorney, and I take a lot of federal appointed work still, you just submit a form through a portal, and if it's an area of expertise that comes up often, there's a drop-down menu of pre-approved experts and their fees. So they make it very easy and very simple to get yourself an expert witness on an appointed case. Even the process to get a new expert approved.
Who pays for that?
It comes out of the Criminal Justice Act budget. My understanding is it comes through the judiciary. It pays for the Federal Public Defender's Office, as well as the what are called CJA attorneys, or private attorneys who take federal appointments. So whatever pool of money exists, there's a pool of money set aside for experts, interpreters, paralegals. So it's I wouldn't say it's the smoothest process,
Sure.
but there is a process to get experts on cases.
Yeah, and I think it's this question probably was meant more in the civil setting, because it is quite a bit different in the civil setting versus the criminal. So a couple more questions, but they both deal with people's privacy rights, their medical records, their HIPAA. Everybody knows the word HIPAA out there, and understands that people have certain HIPAA restrictions on information to be shared. So the first question was, are there protections in place for an expert that is testifying on mental health issues, especially concerning doctor-patient privileges? And if so, how can a subpoena override a privilege like this? Well, we could probably spend a couple hours on the privileges issue. But does somebody want to take first stab at this as judge?
I don't really, we don't really get involved in that area, right? Because if a witness is coming in, either A, the expert's been retained by one of the sides, right? So there's either a release that's already happened, or it's the client has done their own specific kind of release. So
I get involved in this issue a lot, actually.
Yeah, I don't.
At the discovery level, this issue comes up a lot. Can you, Kimball, you want to think, or maybe come up with an
Yeah.
example, and maybe we can talk through it?
Yeah, I mean, I think actually it's done really well in civil cases. So, because what ends up happening is, if for example, the example included like psychiatric records. Well, if we're talking about a case where it's a knee injury case, those are never going to come in if the psychiatric allegations.
Well, don't say never.
Well, they usually will not, right? The reality is that usually the discovery that is permitted into somebody's background is limited to the reasonable scope of claims being made. And so if a person if they have claims of psychological issues, significant emotional issues related to some sort of traumatic event, well, then their history in that respect is going to have to be disclosed, at least within a relevant time period, predating.
So we
that-
know those records,
Right.
they have a lot of stuff in them. I mean, sometimes
Right.
people have been through some significant traumas in their life, maybe even criminal activity against them, and they've been victims of crimes, right?
Right.
So there is some higher protections to that, right? I mean, certainly if somebody requests your client's psychiatric records, even though you're claiming emotional damages, it may be relevant to some point, but some of it may not be, right?
Well, yeah, and in addition to that, so for example, let's say that it is relevant to the degree at least that we need to get them and look at what they are to figure out how relevant they are. Well, there are nice protections in place where, Commissioner, you would order something in that circumstance that I'm going to gather the records and I'm going to bring them to court to you so that you can look at them and you can make a fair decision about what's relevant, what is not, in terms of, or what's going to be in that respect. And then if it's something that's quite sensitive, it can always be filed under seal. So the information really stays between the litigants in a pretty protected way. Anyway, I think the system is pretty good for the most part. Occasionally, I feel like there's a bit of an overreach, for sure, but oftentimes I think that those areas tend to be well respected by the judges, by the commissioners.
Yeah, and to me, there is a big distinction that I've found in the civil and the family discovery on this issue. So let's just talk about civil for the moment, because in the civil context, usually the injuries are well defined. The emotional damages may be out there, and the treatment from mental health issues may or may not be relevant. There's a big issue with regards to a condition called somatoform disorder, where sometimes those mental conditions actually exasperate people's feelings about pain and how they're dealing with life. And so there is actually a condition out there that may necessarily become relevant and proportional to the needs of the case. So as a commissioner, like you said, most of the time we're very, very sensitive with this, and we take this very, very seriously, and we take it in multiple steps. Most of the time, and I'm not saying this is every time, but we will ask that the records be produced, like you said, in camera, and we will review those either under seal or in camera where they're not available to the other side, and we'll make a determination of whether or not they are relevant and proportional to the needs of the case, meaning discoverable. And I don't need to go into that side note there because that's a whole nother day's discussion. But so there is a mechanism to protect it that way, and oftentimes I would tell litigants to go out and get the records yourself, try to control it, and submit what you believe to be relevant and proportional, and then the rest you can redact, and you can identify what it is, or at least categorically, so that the other side knows why you're taking it out, and maybe they won't even fight you on it. If they do, then that's when I have to look at those redactions and see if they're done appropriately. So the family context is a much different, in my opinion, because you're dealing with the best interest of the children in a lot of these cases. And you oftentimes there are experts that are designated to be non-litigation experts, and they want a child to go see a person so they can get some treatment. And they'll literally identify them as a non-litigation expert, and they can't be called as a witness. So there's other mechanisms they have over there to try to protect those types of things. I think it's very important to do that. We all want to make sure that people feel comfortable going to get the mental health care that they need, and to be able to do that. In a criminal setting, it comes into, I imagine, with regards to what type, it's funny, my daughter's taking a course now, and she said, you know that insanity is really not a diagnosed condition? I said, well, yeah, it's just a legal term, right? I mean,
Yeah,
people don't
yeah,
realize
yeah.
that,
Yeah.
but the word insanity is not necessarily a medical diagnosis. There's conditions, right? And then we have a legal framework to determine whether or not that's a valid defense, right?
Right. So Kimball actually touched on it. The process is exactly the same as he described it. The subpoena will go out to a third party. It will go to the assigned judge. The judge will review it in camera for relevance.
Right.
Sometimes if it's clear enough, like if I'm saying, hey, I need the victim's medical records, because I want to see if they were under the influence. Because if they went to the hospital did a blood draw. Sometimes it's the government will say, all right, just sign this protective order. It's your eyes only. You cannot give it to your client. You and your expert or your expert must maintain control of it. And that's simple, straightforward. I've never had an issue.
I've always wondered about that, by the way. You mind if I interject here? How is it that they can keep it from the clients? I'm not sure that you can do that when. But I mean, I know that some judges do it that way, but I've always wondered how that actually comes out, because at trial they get to sit there the whole time. Are you not going to be able to put that evidence on?
So I should have actually been a little bit more clear.
Okay. No, I've heard people say that though.
The client just can't walk out the door with it.
Okay.
Like some of the more sensitive cases, they'll say you can review it with your client ad nauseum, but it has to be, you have to be present. It must be reviewed in the presence of the attorney.
Okay.
Yeah.
Judge, is that how you understood it in those
Right. Well, remember,
situations too?
yeah, I was focusing the question talking about when an expert that is testifying. So by the time they're testifying, we're already past the motion eliminate stage where people try and get out certain information. We're already past the discovery stage. I'm already past possibly reviewing a report and recommendation. I'm already past the idea of documents. So by the time the expert's testifying, it's pretty much known what that testimony is going to be. At least it should be, because they're confined with the report. And if somebody wanted certain parts of that report to be eliminated or certain parts not to be stated, then that's pretrial motion practice, and it really doesn't get to the testifying part.
So we really are, we are really honing in on some very complex issues.
Yeah.
And maybe we should have started a little higher for the overview of what we're kind of talking about here, because I think it's important for people to recognize out there that HIPAA does protect people's rights and what they have in their medical records, but
Only in certain circumstances, which HIPAA specifically defines.
correct. It's not as wide breadth as people think. Secondarily, a person who files an action for injuries waives a lot of those rights, do they not?
Right. Yeah, correct.
So I think it's important for everyone to realize that we already skipped steps 1, 2, 3, and 4, and we're already down to, okay, we're in heavy litigation. How does it look in front of in heavy litigation? So I want to make sure everybody kind of understands that there is protections that HIPAA does apply. It doesn't apply to everybody, by the way. There's some debate about who it applies to and what it applies to. But anyway, the last question, I guess, was very specific to a criminal case, and I wanted to see if I can read it kind of directly. And I think this is what Judge was just kind of inferring. But in a criminal setting, I think the question's pretty specific. Does HIPAA interfere with what expert witnesses can testify to on the stand? And if so, how does this not cause issues in a criminal case, for example, where a defendant's liberty rights are now on the line?
If we're at the point of having the expert testify, if it's my client, I've obviously had them sign a HIPAA release so that I have no issues with it. If it's for a third party or a victim or a witness, the judge has already made the determination that we've already litigated it into the ground, that Yes, these records are relevant. They will help the jury make their final determination, and any sort of protections that HIPAA would provide aren't applicable. And then the belt and suspenders on it is sign this protective order, or the court can enter its own protective order.
So I think it's the same answer as Judge Kishner was just saying, is that by the time it gets to trial and the expert testifying, this should have been dealt with long ago. Whether or not they even have that information is going to be something that's going to be dealt with in the pre-trial stuff, pre-litigation stuff, in the discovery phase or magistrate judge phase if you're over in federal court. But I think the answer is that by the time they're on the stand, it's usually already out there and it's usually already discovered. So those are the topics. I really enjoyed this. I think all of us are so passionate about what we do, and I think it hopefully shows to everybody that we could probably talk about this stuff forever. But I think we've handled any closing remarks, Kimball?
No, experts are a huge part of certainly in any major litigation. They have become a really big part of it, and so yeah, it's something that you have to deal with, and so better figure out how.
Judge?
I just say very timely, very broad spectrum, and well thought out questions. And sorry, that's about all my voice is going to be able to give you. And my apologies, everyone. I've been doing my job so much, I've started to lose my voice.
For my part, I've enjoyed this panel. I've enjoyed sitting here with all of you today, and I hope everyone out there has found this both entertaining and informative.
Yeah, and me too. I think I always enjoy these because you get to really hear from different perspectives, and I always try to come away with something I've learned, and certainly from the criminal law, although I was a justice of the peace pro tem and did some criminal law stuff, obviously this is much more in depth when you're getting into really heavily litigated cases. So I've really enjoyed this. I appreciate everybody's time and hope everybody enjoyed it out there.
Thank you so much.
Thanks
Thank
to
you.
Mr. Falcone for putting it together.